welcome back to Trinidad and Tobago, and we are this time starting on another conversation, and joining us on their Morning Brew at this time, Mario Merritt, well-known criminal attorney in Trinidad and Tobago, and there are a number of issues. You may remember that there was a magistrate, and there was a story that was highlighted in the newspaper about the conduct of police officers in judicial matters. Well, from then till now, the Commissioner of Police has gotten involved, and he took a jab at the judiciary in talking about the magistrates for calling out or for being I guess a little harsh on his officers, saying that their judiciary should basically watch what they're doing and also can't tell the police what to do. Now, in the end, moving forward, the Law Association has looked on this, and they expected to release a statement on this. But the presumption of innocence, the right to be heard, the right for due process, all of these are constitutional rights. In the end, when I understand that the Commissioner is facing rising crime rates, and he talks about the lethargic state of the judiciary, he's not the only public official to put a jab at the judiciary. I've seen that the Prime Minister has also made statements about judicial officers as well. Is it now a pattern or a trend, and should we be worried about the fact that we're eroding confidence in the judiciary? Mario, good morning. How are you?
Good morning. Morning, Trinidad and Tobago.
Now, I want to first start on one issue, and I know this is a little off our topic this morning, a non-disclosure agreement, because the big story that we're discussing is the fact that there is an attempt to what has been described as a cover-up in the Darrell Smith matter. One of the big guys, or the, I guess, obstacles or protection in this is this non-disclosure agreement. It was described as a trade dispute. We all know this as a sexual harassment allegation. It is not a trade dispute, and I do not want anybody to say that. But in the end, there was an NDA, and a settlement was made. What is the purpose of an NDA, and does that mean now that no one will know the details of what took place?
Non-disclosure agreements, NDAs, are there to indicate that when we come to an agreement, whatever we agree to, the contents of this whole process, it's just between us. You cannot talk about it outside, or it vitiates, it damages the actual agreement. It says the agreement is void. But NDAs are only, it's a contract, more or less it's a contractual relationship you're getting into, and the law prohibits contracts that are against public policy. So if you're dealing with a normal trade dispute, it's not a problem. But if you are using an NDA to hide a criminal act, then that agreement is void. It has no value, because you can't use something, a contractual relationship, to allow crime. So that agreement could not stand, ought not to stand. If it reaches to the point of a court, courts will say, well, this is against public policy. We can't allow things that are harmful to the public to be hidden like this.
Now, you know, considering, and I know this is not the topic we're going to talk on, I don't want to delve too much into this. There are allegations, counter-allegations. There was an FOIE that was denied, where I think Cook Waith and his group attempted to find out the details of this report. Now the letter has been released, which names a number of persons, and I know one of the newspapers went into detail. They identified P.S. Mendez, Mr. Joseph, and Mr. Kwamina, Deputy P.S. Arno, and P.S. Ramadin in the early stages of this matter. So a number of high-profile names mentioned there, including public officers. The matter in their mind was closed. Then it became aware that there was some sort of settlement paid for a trade dispute that came out to be sexual harassment. Do you expect someone to now go to the court to release this, or to say that this non-disclosure agreement cannot stand in public interest?
Well, what
would be the weight of it?
I don't know what anyone will do, but I'm saying that it can be raised, that this agreement cannot stand. You can go to court and ask the court, if you're a person that has an interest in this matter, to show that this agreement ought not to be allowed to stand, and it's against public policy, and therefore the contractual situation that exists within it be voided.
So I know that we will continue to see how this one is playing out, and I do expect that one of the groups will speak on this. Now, we did invite Mr. Merritt to speak a little bit about what is taking place, the Commissioner of Police versus the judiciary. Mario, you practice in the criminal bar. The magistrates and the wheels of justice are very, very slow. All of this started because a magistrate made a number of statements describing the officers as basically incompetent, complacent, and not taking their duties to hand. And that may contribute to the slow pace of justice. The Commissioner of Police was not very pleased by that.
I am one of those who's tried to speak out against the lethargic situation with our judiciary and cases taking 10 and 15 years. But in this particular case, because I've practiced in front of this magistrate, this magistrate is an equal opportunity offender. In other words, if you do something wrong, he's going to be down on the prosecution as equally on the defense. So he is a straight-laced kind of guy. You do it, something that's not accurate, he is going to take you to task on it. And his comments, well, I listened to the comments of the magistrate, and to me, they rang true. In other words, the things he was asking the police, that everybody who practices in this arena would know that, yeah, those things, the court isn't responsible for those things, it's the police. So that I'm asking myself whether the commissioner did any investigation before he made his comments. I'm questioning that, because all police officers, well, all real police officers spend some time in the barracks, and therefore they would be familiar with court procedure, they would be familiar with rules of evidence. But I'm not sure whether the commissioner had that training. He didn't come from the police service, so he may not know exactly and may not, but he needs to take advice. And one of the pieces of advice he needs to take is not to talk so much, because these are things I'm sure he doesn't understand. But
do you know, see, we can all agree that the judiciary works very slowly.
Yes.
And is the commissioner not within his right to raise issues about what he sees as an unfair attack on his officers?
Everyone has a right to criticize the judiciary and the
Because it's not a sacred cow.
Yes, it's not. But your criticism must be, one, fair, and it must be in a manner consistent with keeping the judiciary and the magistracy in the public's view as something to have respect for. But if you go about picking on a magistrate that cannot respond, because the magistrate, he cannot respond to what the commissioner says. The commissioner goes and speaks, the magistrate has to just, if you want a reply from the magistrate, go in his court and ask him the very things you're saying so that he can respond to you in the courtroom itself, and you put it on the public domain. But what he did, and this is important, he gave the impression in his speech that, this is the commissioner, that there is some special relationship that exists between the police and the magistracy.
But he's not the first person. Being critical of the judiciary is not. The Prime Minister has made similar statements against the judiciary.
Yes, but when you target, and this is the manner of the criticism in this particular case. The manner of the criticism in this particular case is to say that, you know, we have a special relationship, why are you trying to damage it? Which is what many of the criminal elements feel that way too, that there's a special relationship between the judiciary and the police. That in itself creates a situation where the judiciary and the magistracy, their lives could be in danger.
Do you think that the criticism of the police officer was warranted at this time?
Yes. I don't know the actual specifics, but the questions that the magistrate asked, that about bringing the person on time and those kinds of things, we all go through that, because you would put your client who get arrested one day and charged on that day and not taken to court. Say you charged on a Monday morning, he doesn't get to court till Tuesday evening. So you ask yourself, you charge me on Monday, why can't I get to a court in time to ask for bail, for other things? No, so I think I don't want to speak specifically on every single aspect of what the magistrate said, but the magistrate was trying to figure out why is the magistracy being blamed for something that is not our responsibility.
Are they not a serious stakeholder in the judiciary?
The magistracy? Yeah, of course they are. But in this particular case, the things that the magistrate itself was being chastised for, I don't think it's his responsibility to do those things. It was the police responsibility to have the prisoner brought, to have them there at a reasonable time for the magistracy to be able to issue bail or not issue bail. And if you don't do that, it can't be. It's not for the magistrate to walk the person from the police station to the court. So,
you know, a lot of people looking at this interview this morning, Mario, and I see that the Law Association says that they're going to respond on it. Are the lawyers now defending the magistrates?
I don't think we have a duty to help in the administration of justice. And that sometimes means defending and sometimes means criticizing. So when the magistrate or the judiciary is acting in what we find a manner that is inconsistent with the administration of justice, we have to speak out. If we find that they are being attacked unfairly, which has the tendency or the potential to affect the administration of justice, we have to speak out. I find it amusing that the Law Association sent out a press release, that they're going to send out a press release. I think that they ought to have met and spoken about this already, because it is an obvious situation where the magistrate himself, as I said, because by nature of his office, he can't defend himself.
But let me ask you this, you know, looking at the Commissioner of Police and his position, he's the crime fighter of this country. He's put up in a pedestal and people are expecting, and Gary Griffith has the public support behind him. That, and he calls out at the judiciary for what he sees as questionable let's bring back to the point of the bail with the 9 rifles. And I know he made reference to it. I heard the Prime Minister made reference in instances where he questioned the conduct and how magistrates are now granting or being lenient.
The thing about it is, the Commissioner himself, yes, he's popular, but I would hope that anybody who's trying to fight crime would be popular. But I find his comments a bit distracting, because what I would want to know is he lobbying as hard for the cameras, body cameras? Is he lobbying as hard for the tasers? Is he lobbying as hard for those other aspects of his actual job? Those are things that he actually needs for his actual performance. So that
yeah, but the pace of justice also affects his ability to do his job, because if persons are being released, or if persons are being released back into the public domain who he thinks are questionable, is he not within his right to say that?
But you see, bail itself is not a punishment. You know, it's not something to say that you've committed a crime, spend 2-3 years in jail, because that's what eventually happens if you don't get bail. You spend 2-3 years waiting for your matter to even be contemplated to start. So the point of bail is whether or not there is reason that this person will attend at his trial. That is the main purpose of bail. It's not to be a punishment. So when you say, oh, you're letting go people, until they're found guilty of the actual crime, they are entitled to bail. So the question is, and the magistrate in the very circumstance would have an opportunity to look at the things that the public are not aware. The actual strength of the case against the person isn't a factor the magistrate has to take into consideration. So if the magistrate sees that, well, you know, you said the press had this view of the crime and what they could prove. But when the magistrate hears from the prosecutor, this is the actual state of the affairs, well, he's saying, what, I don't think you have a strong case.
Do you think the judiciary is inhibiting the national security apparatus, and I don't want to personalize this about the Commissioner, national security apparatus from doing their job?
I don't understand that. What? Explain.
So when you look at, like, I know there are black and white rules about bail.
Yes.
And in terms of there's a litmus test that must be granted if you're a first offender, second offender, and the nature of the crime. If it's not within the law, it's within the leniency of the magistrate. But do you think, considering all of that is happening, that the judiciary is now not in alignment with what the public wants, with what they see as a crime fighting, what they see as a national crisis?
You see, the judiciary, this is why I still support the Privy Council. The judiciary needs to be independent. And the public may not agree with everything the judiciary does, but the judiciary must not feel pressured in a particular direction. It must feel that it can negotiate the law and the society in a fair manner. And not because the society feels a particular way, that doesn't mean the society is right. Because a lot of us act on emotion as opposed to clear, simple logic as to how to deal with particular things. It is their role, their responsibility, their function to be independent, have a clear judicial mind when making decisions, and to not be so influenced by the public outcry that they make erroneous decisions. If things had to change in that respect, Parliament must change it. I don't often agree with some things Parliament does, but they are the rule makers. So if they don't like how judges are doing their job, which I think they are the ones to change it. But judges are not supposed to change the way they do their job, because they have a particular, it's skills developed over years.
Are you now, and I know we have to take a quick break when we come back, we have a couple seconds again with this interview. We're going to ask whether or not the judiciary and the lawyers will now end up on the wrong side of public opinion. Stay with us. Welcome back to Trinidad. What you're looking at right there, you know, so actually today's Halloween. And what we're seeing are live shots there of Aruna Miraj and Kerry Mohammed. And they're creating two of the popular characters for Carnival. Yes, should be. What they're doing there is two of the popular places. If you're wondering what's happening there, that's what's taking place in our makeup room at this time. Two of the popular characters, Joker and Harlequin. Definitely, we're going to check in with them in a couple of minutes. And we're returning to our conversation now with Mario Merritt. Mario, looking at the fact that the public sentiment would be that the Commissioner is exposing what he sees as questionable practices and weak magistrates, and that in the end, they are charging them. But when the police do their jobs and persons appear before the magistracy, lawyers are getting them off and magistrates are getting them off.
Lawyers,
that is the public statement.
Lawyers are getting them off because of poor police work. That's the way we get people off. When the police don't do their work properly, they allow for loopholes, they allow for things to happen that the citizens are entitled to the advantage of. So that one, as I keep saying, everybody, I don't think there's a person in this country that does not want Mr. Griffith to succeed. But we want him to do it correctly, the proper way. We don't want, at the end of the day, that we are in a police state where the police could do whatever they want, treat people however they want, and we accept it. Because not just criminals live here. Good people live here too. And we want to know that they are also protected from the very police. We've had enough cases in the courts where the state had to pay people because the police did things badly in civil courts. So this country has lost money in the civil courts because of poor policing. Taxpaying dollars go to pay people because of poor policing.
You're standing here and are you now afraid by making this position and standing out in the public domain that lawyers and the judiciary or magistrates will now end up on the wrong side of public opinion? Because you have the public defender out in the form of Gary Griffith talking about this, exposing this in his mind. You then have the Prime Minister also saying that there are questions in his mind. You have statements where people believe that lawyers are the biggest beneficiary of a broken judicial system, particularly the criminal bar, and you also have magistrates now. So are you now afraid of that you all are going to end up on the wrong side of public sentiment and public opinion, the court of public law?
I'm not a politician, so that all I can do is my job. And if I do it to the best of my ability, that is the satisfaction I get. I am not concerned as to whether or not the public, because as everybody knows, there are so many jokes about lawyers, but that if I were to take on the public opinion, I'd never be a lawyer. So that the point is to do what you do and do it to the best of your ability. It doesn't matter. And you say he's a public defender. I'm not. He has a job to do. His job is to help reduce the crime rate. I don't know whether that makes him a public defender or a policeman.
Your closing comments on this matter?
I would want Mr. Griffith, who I want to succeed, to be careful of the statements he makes. There is a skill in staying silent that allows your work, your work and your deeds speak for you. Not always be the first person to say things and it not be accurate.
Do you think the country is not wanting of leadership at this time, and he believes by doing that he is showing the take-charge leadership that the country wants?
But again, what we want is we want things done correctly. I think if the country has a choice between things being done correctly or things being done badly, they would choose correct. And therefore, he is in the forefront. But you must do it correctly. If you want to criticize a magistrate, which you are free to do, make sure your facts are correct. Make sure you understand the issues. And there are procedures you can actually make a complaint, because there are complaint mechanisms for the judiciary, but not in the public opinion, public domain, where people, the magistrate, is unable to defend himself. The person who does that is a bully. If you tell somebody things and knowing that they can't respond to you, you're bullying.
Yeah, but in the end, I mean, this is going to be a public discourse, and you're saying that you're not afraid of being the wrong side of the public discourse, but the population, listening to what Commissioner Griffith and the Prime Minister had to say, and looking at the affairs, because they're saying that these persons are being released. You are presumed innocent. There is a litmus test of evidence that must be tested before the nation's courts. Magistrates are guided by rules. We will continue to look at this matter. But Mario, thank you for joining us this morning and sharing your opinion on it. We take a short break. When we come back, we're going to share with you another set of shots. We look at what's taking place in our makeup room this morning.